Anthony Mento here, along with my friend and associate Lena Storm, one of the smartest people in our industry that I've ever encountered. And we're lucky to have her today to talk about the Connelly case. And in my opinion, one of the single biggest opportunities for business owner clients to kind of restructure their ongoing buy-sell agreements to comply with a very recent ruling that most business owners, accountants, attorneys may not even be familiar with, or how the valuations interact with their overall estate planning. So, I want to thank those of you who joined us on the East Coast, and good afternoon, and for the rest of the country, good morning. We'll spend about 45 minutes, and we'll give you the highlights of what the heck happened in this case, Lena, and we'll get into like what we should be doing now, and what the next steps are. I mean, there are countless articles and white papers and very complex, webinars that you can attend that are, somewhat convoluted with tax code and opinion and analysis. We're going to kind of get right to it today and like talk about what happened, what you should be doing, and the next steps. So, Lena, again, thank you for joining us, and we're lucky to have you. And I'm gonna toss you several questions here to kind of walk us through what happened. But first I'll talk about where we are from a business continuation opportunity and landscape of the business owners. The last 3 to 4 years, arguably 2019 forward, have had a really big impact on valuations. So, there are many buy-sell agreements that we look at that have a stated value that have never been updated since 2019. And one would say that's like, step one is to kind of get reacquainted with your agreement and what it's going to do for you. There's a silver tsunami of 3.5 million baby boomer owned businesses that are going to transfer to one party or the other, coming up and actively seeing that. Connelly, which was a landmark case that the Supreme Court ruled on in June of 2024, that's going to redefine how we look at buy-sell planning and this natural transition to estate planning. Because many clients that we work with and that you work with, Lena, most of the time their biggest asset is their business, right? Which is the huge impact on their estate plan.
They may not even realize how significant an impact it is until it's a little bit too late.
Absolutely. And we're seeing, right, based on a market analysis of like 25,000, buy-sell agreements. The data is current as of like December of 2020. The biggest industries that we see impacted are professional, scientific, and technical, construction, healthcare and social assistance, manufacturing, and wholesale trade. So when you're thinking about, who am I going to talk to, who should I be engaging, right? Of those 5 top industries, 62% of them have 24 or fewer employees, right? So these are like your next door neighbors. This isn't, you're not looking for Coca-Cola or Disney, right? You're looking for the closely held business, and 57% of them are corporations, either S or C, which lend to planning. So, I like to joke, like, up through June 6, 2024, everyone had a plan until they get punched in the face. So that's a quote by Mike Tyson. These are not Lena's words. They're Mr. Tyson. She's far more ladylike than that, but it does kind of get your attention that, the plan you had yesterday may not be appropriate today. And right, the benefits of an effective and well-funded agreement allows you to have, right, the right amount of funding in the right place at the right time, which you'll see at Connelly maybe didn't line up exactly, how it should have. You're gonna think of different, choices of agreement, right? We're gonna talk about cross purchase. We're gonna talk about entity purchase, which is at the root of the Connelly issue. Some wait and see, some third party structures, and Lena is going to talk about the retirement buy sell. If you're an insurance professional, and this is a really cool way to kind of restructure your buy sell agreement. What you want to consider before you decide on the type of agreement is the tax structure, the accounting method, how many owners, status of potential successor, right? Are you going to sell? Is there a known or unknown? Is it a third party? Is it a key person? Is it next generation family? And what are the estate planning objectives? So let's get into some basics of a buy sell structure, and not to be so elementary, but I think it's foundational in understanding like where Connelly came from. Lena, give us some color on the two major types of buy sell agreements, and one being a cross purchase. Can you like high level the cross purchase for us?
Absolutely. So in a cross purchase plan, which is the simplest plan, and we would do them for everybody if there were only 2 or 3 owners. Problem is we have many owners at times, but the cross purchase plan is simply each owner owns a policy on each of the other owners. And this way, if one of them dies, that person who owns the policy on that deceased owner gets the proceeds, the death benefit proceeds, and then can use those proceeds to purchase the shares from the heirs who the business interest was transferred to. That's a real basic cross purchase design. The good thing about cross purchase is that those surviving owners who purchase the deceased's shares get a step up in cost basis to the fair market value at the death of the deceased. So if your value of your shares went up, those shares you purchased as a surviving owner also went up. So that's a benefit of cross purchase. The problem with cross purchase is, again, if you have too many business owners, it really gets cumbersome to manage many policies. That means if there were 5, I'd have to own 5 policies, one on each owner, and then the other owners would each have to own on each of the other 4. So it gets cumbersome, but that's the basics of cross purchase.
I'll bet, Lena, later in the slide presentation, you may have a creative way to use a cross purchase in a larger than 2 audience.
We will discuss that. Yep.
Almost foresee that coming. So the cross purchase is likely to increase significantly because of Connelly. Connelly again was affected by an entity purchase. So Lena, just some quick color on how's the entity purchase differ from the cross purchase?
The entity purchase, again, was the subject of the Connelly case, was always so simple because it's just the entity, the company, owns one policy on each owner. So if you had 2 owners, or you had 5 owners, or you had 10 owners, partnerships, whatever, they would own a policy on each owner. So many companies feel this is so easy, let's do it. Now, one of the drawbacks of an entity purchase is that you don't get that step up in the shares, in the value of the shares as a surviving owner or the company that redeems those shares with the death benefit. So that was always kind of an issue, but for the most part, it was the simplest way to do a buy sell. And so in Connelly, there were 2 brothers who both had an insurance policy on each of their own lives. Actually, the entity owned a policy on each of the brothers' lives, and then the death benefit paid out into the entity. Now, there's a case. What's important is one of the other reasons why we use entity purchase, or in the past we have, is because there was already case law from 2004, Blount versus Commissioner, where the court said that the question was, will the insurance proceeds swap out? Can they be swapped out for the business interest? And the court said yes. So we had very firm authority, not technical authority, but pretty much we felt comfortable with the entity purchase buy sell. In other words, the money goes into the business, the death benefit from the life insurance policy on the life of the deceased, and then the company redeems shares by asking the heirs who received those shares by doing a swap with them. So it's not that the company would first get the death benefit, that would be part of the value of the business, and then do the redemption. People were concerned about that. Would the obligation under the buy-sell apply? And Blount told us absolutely, it's an even swap. 3 million comes in and then you do the redemption because you've got this agreement. So it's a swap, it's a wash between the two. But in Connelly, what happened is the Supreme Court said, actually, no, the life insurance proceeds will come into the business. We first value those proceeds as part of the business value for estate tax purposes. And then if there's a redemption agreement, then that's done secondarily.
All right, so before we get into the mechanics of Connelly, and this will kind of set up like where we're headed. The business valuation kind of goes hand in hand with the buy-sell agreement, right? You want to make sure that it's up to date and accurate at the time an event occurs, which is one of the issues and challenges with Connelly, right? You want to either name a fixed or a determinable valuation based on a formula, or go out and get some appraisals, or use a formula based value example, right? Is it 5 times EBITDA? So more important for estate tax purposes, owners need to follow the protocol established in the agreement, right? So if you have an agreement, I mean, you should absolutely be following it, right? Which was one of the hiccups in Connelly. So let's dive in and get back to like what happened here, Lena. You talked about two brothers, Michael and Thomas, and they had an entity purchase, and the agreement called for an annual determination of value, right? And they didn't do that, right? I mean, how many buy-sell agreements we get our hands on and we see, a stated value that to be updated every annual shareholder meeting, and the shareholder meetings are at the Phillies games, and you don't even talk about business at the Phillies game, and you kind of like ignoring this very, very, very important stated value. And if you don't get to an annual determination, then the backup method was to go out and get an appraisal or 2 or 3, whoever the agreement reads, right? And also in your agreements, you want to speak to whether how the life insurance proceeds, if it exists, how is that going to be used? How is it going to weave itself into the buy-sell agreement? Is it excluded from business value? And how are the proceeds going to be used? So, Lena, tell us like where Connelly went wrong and kind of what happened here.
I think, there are two things that happened. When the IRS required Connelly to pay the additional estate tax because they did not include the full amount of the life insurance proceeds, obviously, because we were under the impression that the redemption would not require us to include the life insurance proceeds, it kind of defeats the whole purpose. They went back, and we believed it was because of all these issues you just brought up. Because one, the evaluations were not done annually. 2, they didn't follow how it had to be done. They had an alternative to look at different appraisals, even at death. They didn't follow that. So they didn't tie any of the valuation to the agreement. But what was interesting is the tax court, so the IRS said that it was appealed to the tax court, and the tax courts agreed with the IRS. This is before it got to the Supreme Court.
Yep.
But the tax court believed that there were basically Connelly did not follow all these rules, Anthony. Like they didn't follow any of these rules.
Clearly.
But when it got to the Supreme Court, it was a completely different story. That's why this has sort of thrown everything, a monkey wrench into everything. The Supreme Court, who basically they are not estate planners, they are not business valuation specialists, they don't understand any of this. And they just made the decision, well, it's logical that if the proceeds go into the company first, then it's a matter of just looking, the company already was valued higher because those proceeds came in. So the estate tax value of that business should be higher and the redemption value of that business should be higher. And so we don't need to think about any bad facts or the fact that the agreement didn't tie the life insurance amount that was purchased or the valuation to it. So there were two things. It was all over the place. We'd love to be able to say, oh, there were bad facts in this case. They didn't do what they were supposed to do. They didn't dot their I's, cross the T's, make sure the agreement had the right valuation. It was done properly. They explained the method they used. They did it this amount of times, or when he died, they have multiple appraisals. They didn't do any of that stuff. Then we could say, well, Connelly's a little bit of an outlier. If we could go to our customers, to our clients and say, listen, this is what happened in Connelly and this is the prescription. We need to make sure we look at your buy-sell and we do all these things. But the Supreme Court's decision was not at all based on that. So we're now stuck on finding an alternative way of doing these buy-sell arrangements because the highest court, which cannot be further appealed unless Congress changes law, has said that the entity purchase is going to be structured so that the insurance first goes into the company and gets added to its value before a redemption takes place, regardless of how you dotted all your I's and you crossed all your T's.
So that's great, Lena. So let's get into like the real numbers and applications. So Michael's 77% owner, Thomas is 23% owner, right? Michael dies and $3.5 million of death benefit comes into the company. The business then says, okay, we're going to value Michael's shares, 77% of the company, for $3 million. It's completely arbitrary, right? I mean, completely arbitrary. So, Michael's estate then argued, separate issue, that $3 million is the value of Michael's shares for estate planning purposes, right? Michael had some wealth, right? And this goes back 2013, right? Correct me if I'm wrong, Lena. This is like 11 years in the making. This is not new. So the Supreme Court agreed with the Eighth Circuit. We in the industry, right? The students of the industry, I'm an insurance nerd. I thought for sure the Eighth Circuit just misunderstood. This is like way off base. This will never fly. If we're lucky enough to get it to the Supreme Court, I hope and pray it gets there. This is going to be overturned in a second. But actually, it went quite different than what we had anticipated. And they found that the agreement didn't lock in any type of value because they arbitrarily determined the valuation basically based on how much insurance that came in. So, you can't really, so the court says, okay, we're going to determine fair market value and we're going to decide that after the life insurance proceeds came into the business, it then increased its non-operating assets by 3.5 million. So we're going to value the business at 6.86 million, and 77% of that is 5.28, not the 3 million that you kind of wanted to just arbitrarily make up. So therefore, sorry, Michael's estate, you're going to owe another $990,000 of federal estate tax. Kind of wild, right? That that the insurance proceeds. So like, oftentimes, Ray, I'm going through the fact pattern with producers, and they're like, then why would anybody buy insurance? Well, it's just compounding the problem. Well, I would argue that thankfully they did have liquidity to effectuate the buyout, and it's not the insurance that was bad, it was the structure and the facts and circumstances that were bad. So life insurance is still the most efficient way to fund these buyouts, right? Thomas would have been in a world of hurt if he had to engage with a bank loan or installment sale or pay $3 million from company assets, which they didn't have. So the Supreme Court held for the IRS that, hey, you didn't follow the procedures based on your own agreement, right? Not our agreement, your own agreement. Therefore, the IRS was free to determine the fair market value, right? So number one is you have to not just have a current and accurate agreement in place, but you need to follow the agreement. I mean, it seems like it was almost completely disregarded. And the court agreed with the IRS position and the lower court's position that the death benefit did in fact increase the fair market value of the company. The redemption requirement, like you had mentioned in the Blunt case, was not a true liability to the company, but simply required like cutting the company into two parts between operating assets and non-operating assets. Lena, anything to add here based on the set facts and circumstances?
Just say that if Connelly hadn't screwed up their buy sell and this hadn't gone to Supreme Court, we would have been fine today. So just remember that they kind of caused these kind of issues, but I just wanted to add that now we have a new rule and we have to follow these rules.
Here's just kind of like my observation in this, which means, not a whole lot. And Lena, chime in, but I think this gets sorted out somewhere, somehow in tax court land. I don't feel like the Supreme Court had all the facts and kind of left a lot of room for interpretation, right? In oral arguments, right there, they're saying that, like they know like 32% of plans are entity wait and see. I mean, it's just like they're not saying never would it offset as a liability, but if you kind of read the documents, you kind of see some wiggle room here. But the question that I would beg to ask is, do you want to be the one case that has to go set this straight? And right, there's 11 years in the making on Connelly. Imagine, the expense and the time that it would take to kind of set the record straight with your own facts and circumstances. So, in our world, we are just encouraging different structures of buy sell and avoiding being the guinea pig in any stretch of the imagination. That's doesn't sound like a fun experience.
And it's easy enough to do. It's easy enough for many situations to restructure these things, but you've got to speak to your clients, you've got to speak to people, and you've got to tell them about this.
Yeah. So I would say who's most impacted, right? If you're kind of looking for the clients that need immediate attention, right? Who are they, right? You can't talk to everybody. You just want to kind of hit the folks that really will be impacted the most, right? And I would say that they would meet two criteria. If you work with a business owner that has company-owned life insurance for buy-sell planning, and right, that's criteria one, and they have potential exposure to federal or state estate or even inheritance tax, they are like tier one prospect, client, insured, however you want to reference them. They need your attention first. You'll also want to consider other potential impacts on like the price of buying out a deceased owner and ambiguity when price under the agreement differs from fair market value. You also want to help folks that are relying on the Blunt case as authority, which has been effectively overruled. So, right, one of two, both criteria, right? Criteria A, company-owned life insurance for buy-sell planning, and criteria two, potential exposure to federal estate or inheritance taxes. The exemption right now, $13 million. The exemption is set to sunset in 2026. The Harris plan that was just kind of reworked in the affordable housing bill is calling for a $3.5 million exemption. So I would address these things immediately while you can and while there's some flexibility in planning. Lena, besides reaching out to the clients who are most impacted by Connelly, getting a copy of the buy-sell agreement for review, conducting an informal or formal business appraisal, which the team at Life Brokerage can help in all aspects of those exercises. Then what? What should we be doing now? What are you teaching at Mass Mutual? What are you designing? What are you studying? And where are you taking clients as far as a recommendation on what to do from here?
Well, as you mentioned, the first thing is go back and look at their buy-sell arrangements. Are they funded and how are they structured? Those two are the two big questions. If they're structured as an entity purchase, as you mentioned, then if they are exposed to estate tax, or they feel that the growth of their business will make them exposed into the future, then you need to kind of talk with the attorneys and restructure the plan. If they're under the exemption amount, they don't think their business is going to grow. They're going to sell it in a couple of years. They know they can only get something less than 6 million or less than 12 million, depending on who owns the business. Then it's not so much a priority. But those are the first things you have to do: is figure out their buy sell that's funded, what kind of structure it is, and if they don't have one, start from scratch and consider whether they can do an entity because they won't be exposed, or if they need to do something else. The second thing is to look at cross-purchase arrangements. And there are a number of those types of arrangements, including, what we just discussed, the vanilla, everybody owns the policy on each other and you're done. But you also have the ability, for example, to use a retirement buy-sell, which we'll talk about in the next slide, but I'll show you how that's structured. But generally, it's everybody owns a policy on their own life, and then they rent out the death benefit to each other for the economic benefit or the term cost of that death benefit. And then at the end of the buy-sell term, they just terminate that and they just own the policy free and clear. So that's something. And then the other thing is the insurance LLC. Some people are concerned, oh, that's an entity. But an insurance LLC can be created so that the business owners can become partners if they're not already partners in an LLC, which also has creditor protection. And that LLC can facilitate the buy-sell arrangement. You establish the buy-sell arrangement between the LLC and the deceased and every owner. You fund a life insurance policy on the life, so it is like an entity of each owner. But because there's an operating agreement in an LLC, you can actually allocate the death benefit proceeds when they're paid out into the LLC to the surviving owners. So there should not be, until Supreme Court, somebody says something else, there should not be exposure to an increase in valuation for estate tax purposes of that interest. So the insurance LLC, I suspect, will be something we're going to see a lot more of. And so that's something that's very, very easy. The other thing with the insurance LLC is it really is helpful for a lifetime buyout, because the policy, if it's a permanent policy, can be transferred to the person who wants to buy out as part of the purchase price. And so it makes it really, really easy to facilitate that. The other thing people may say is the wait and see buy sell. Let's touch upon that very quickly. The wait and see is basically the business can buy at the deceased owner's death, can buy that share, or the other owners can buy it. And so the business has first option to buy it. The other owners have second option. And the nice thing about that is that the owners can own the life insurance policy themselves as a cross purchase arrangement. They just own it on the other owners. And then if they end up getting the option to buy, they can exchange shares with the proceeds that they receive with the heirs. If they don't get the option and the business does, then they can make a capital contribution into the business from the LLC in order for the LLC to have the money to redeem those shares, or they can lend the proceeds to the business that they are part of, and then the business will have the money to redeem the shares. So there's a lot of flexibility in a wait and see, which I think is what the Supreme Court was trying to say. Well, everybody uses wait and sees anyway, but that's actually not true. So that still is an option. The other one is here, it says escrowed buy sell or trusteed buy sells. Separate from Connelly, they've always kind of been an issue. One is, how do you get the premium dollars inside the trust? And then two, we really don't know if those escrowed, the proceeds are going to be subject to estate tax in that situation. That's always been an issue with a trustee or escrowed buy sell. So, but that's a possibility. So those are sort of the structures that we're initially looking at, is the different types of cross purchase direct or with a wait and see, as well as the retirement buy sell or the insurance LLC.
So plenty of options to overcome, right? It just takes some skilled professionals to help draft, to help facilitate discussion, right? And we can certainly, help you with that. One of my favorite techniques, and oddly enough, a technique that we were at Life Brokerage between my partner Adam DeMarco and I were implementing before Connelly was ruled on, was the retirement buy sell. I'm several years older than Adam. We have inequitable shares. We're an LLC taxed as an S corp, so getting K1s out to one another in an equitable fashion is not conducive, right? Could jeopardize the S selection. So we landed on this structure, and oddly enough, it comes to the forefront as a planning tool in light of Connelly, which we did not foresee coming, but we're a little bit ahead of the game as far as execution. Lena, being a big fan of cash value life insurance, and recognizing that businesses are a very large portion of most of our clients' net worth, personal net worth, walk us through the retirement buy sell strategy.
Sure. So the retirement buy sell really is a cross endorsement split dollar arrangement. And all you're doing is you're splitting the values for a period of time, and then you're ending and you're paying something for that period of time. So in this situation, as I mentioned earlier, you each own your own policy and you rent out to each other of the death benefit. It could be the full death benefit or a portion of the death benefit, and you pay the economic benefit or term cost annually based on what you're renting out, or what we call technically endorsing out to each other.
Yep.
And then the next, yeah, go ahead.
So Lena, in the case of, let's call it Anthony and Adam, I get to own my own policy, right? I'm gonna apply for it personally. And I'm gonna complete all the business supplements that are, required on the application, because we're gonna treat it as a business case, but I'm gonna own it personally. And whether it be term or permanent, I then have the ability to rent just like any other asset, right? A vacation home, a vehicle, right? If I decide I want to Uber or Airbnb, I'm certainly allowed within my rights to rent the death benefit portion of the policy to Adam, right? At fair market cost. I can't treat him any differently than anyone else. So I'm going to go to the insurance company, you at Mass Mutual, for one, and you can provide me what that stated rent or fair market rent it would be appropriate for me to charge Adam. Is that correct? Did I understand that?
Right. That's right. We use either the alternative term rates that the insurance company provides, assuming that they qualify under the regs for using that table, or you use the table 2001 rates, which are a government rate, which is usually higher. So we try to use the alternative term rates, but almost every reputable insurance has those that you can use and they all qualify. But the thing is in Anthony, in this scenario, you rent out that for the cost per thousand based on your age, and every year the table goes up based on your attained age. But you can offset, so you're paying the rent, but the only thing you're really paying is you're going to offset what your partner gives you. So in your case, you're giving a rental income and you are paying rental income. You offset each other and then you pay tax on the difference. So
Gotcha.
it really can be extremely minimal, at least, in your earlier years.
Correct. So you're just going to impute the difference. In this case, right? My rent's a lot more than Adam's, so he's going to impute, right, some phantom income or economic benefit in this instance. So conceptually, you're trading value, but on paper, it's truly just an offset and an accounting strategy.
That's another example of how life insurance is so flexible as a property, as a piece of, as an extra asset you have, because you can have it for the needs you need it for later on and for now. We've also set it up where you can split the death benefit. So let's say you only need a portion of this death, the rest of it will be used for other needs that you may have.
Well said.
So the next slide,
So
I
what
believe, yeah,
happens?
yeah.
What happens? Walk me through as I die prematurely. And how does this work?
Yeah, because people actually ask, they say all the time to me, is like, well, then how does it work later? You own the policy. How are you going to facilitate the exchange? Well,
Mhm.
basically, the rented proceeds that Adam rented from Anthony goes to Adam, and then Adam um, gives the proceeds to the heirs and says, this buy-sell arrangement, it says that you are obligated to exchange these shares with me. Here's some cash from the life insurance, and then give me the interest. And then that's how you exchange the two. And so that's how it would work on both sides. And it's an obligation that under the buy-sell. So the death benefit proceeds goes to Adam. Adam then turns around and exchanges shares with the heirs who received those proceeds, at Anthony's death. And then now Adam is free and clear in his business. He doesn't have the heirs as business partners. He can either go find another partner or own the entire company himself.
All right, so that's the sad outcome. The happy outcome is that we just no longer, right, have the need to do this anymore, and we kind of tear up this rental agreement, and there's no transfer for value issue, there's no tax implication, and now I have this in this instance, we'll say, a very extremely cash rich, let's call it whole life, right? Dividend paying whole life that's just exploding in value year over year. I'm literally printing money risk free. And I'm, past the 11-year mark where I did a 10 pay. Now I get to utilize that asset as a volatility buffer, as my fixed income bucket. To hedge against sequence of returns and volatile markets, and I get to weave that into my cash flow and retirement planning without the complexity of, hey, Adam, you think you can give me my policy back? Or oh, well, I don't know, Anthony, you're not looking so good. I might want to hang on to it. Well, can I buy it from you? And you're getting into all those complexities. So this kind of cuts down on all the back end complexities and movements of the policies, and I there are some rules to play by, right? Like Lena, like we will need to establish a bona fide partnership and some things to kind of button up the appropriateness of this and make sure that we're well within the code and the rights to do this without triggering any unexpected tax consequences. But this is a great strategy, and we try not to promote product or sale of product on these webinars and use them as educational, but your mind should be working at this point on how you can utilize cash value policies to fund buy sell agreements using the retirement buy sell at death. And I will say, and again, another credit to Lena, she has built one of the most robust modules in the Mass Mutual Strategic Distributors platform called Simplify, where she can actually drop illustration values into this concept and show how it works, speak to the rental costs, give you some client output, some educational material, and kind of walk you through how it works and specific to your client situation. So, Lena, I don't say that enough. It's probably the best advanced markets module of any carrier that we work with.
That's great. The other thing I would add that I did forget, you may have mentioned it, is that with the retirement buy sell in the structure, you do get the surviving owner does get a step up in basis as well for those shares that they purchase. So that's important. And then the other thing I would add is that you could always do a, let's say you're in a corporation, you have a client who has a company, a C corporation, you could do a split dollar that actually is on top of this. So it's a double split dollar because this technically is a split dollar. So you could split dollar the premium with the company, have a high cash value product that pays the company back at X number, year 11, 12, 13, and then have this policy still continuing to be rented out the way we described it, and then, terminated at retirement and used for retirement. But the great thing about that is that you may be able to use the company coffers to pay the premium on this to begin with and have the policy pay the company back. And, you basically kill two birds with one stone.
Yeah, very creative. Lena, if the insurance is in a closely held corp, what if any discounting strategies may be available for getting the policies out of the corp and to annihilate or back to the shareholder? Or what's the best way to kind of remedy a corporate owned life insurance policy that might be affected by Connelly?
You can do a transfer
Yeah,
of the policy if the transfer is to an insured or a partner of the insured or a partnership or to a corporation where the insured is a shareholder. Those are exceptions to the transfer for value rule. So if you want to get it out of the current Connelly prone entity purchase arrangement, as long as you can meet one of those situations, you can actually get it out. If you created the insurance LLC, then that should be a little bit easier, right? You can move it over into there. It's also, you could do that first and move it into the insurance LLC. If you decided you didn't want to do the insurance LLC as the buy sell mechanism, then you would own it there and from there decide what
yeah.
you were going to do with it. So it could be a step to wherever you're going to go, depending on the particular situation. Um, I don't know if you have it here, Anthony. I didn't want to, the, a lot of people, especially CPAs, always say, well, we'll just take a loan out. I'm worried about this because of Connelly. They may say, you know what? Don't worry. We'll just take a loan out at the time. Plus, if you qualify for 35% or more, your business represents 35% or more of your entire estate, you can use Section 6166, which is basically a government loan to pay the estate taxes over a 15-year period. And so we have to be prepared to explain why those things are not good. So I wanted to bring that up.
Very good point. Very good point. So the impact of Connelly on existing entity purchase agreements left in place, right? Kind of like, are you going to buy out the higher amount? Like, so let me ask you, if the IRS feels as though the valuation is increased by, call it $3.5 million, $3 million or $3.5 million in Connelly, wouldn't the surviving spouse be looking for their share of the increased valuation? Does this cause buy sell friction between the surviving partner and the surviving family members?
Absolutely. So you're going to have to figure out how you're going to facilitate that. So one of the things, the reason the retirement buy sell actually would work out much better is because let's say you had to compensate for the fact that Connelly increased the valuation by the estate tax percentage, let's say 40%. And you did that. You could easily do that. We do that all the time. So you're buying more insurance in order to pay the tax. And so you don't want to get into a circular computation. So you could do that. But if you had a retirement buy sell, then that death benefit would be higher. And if you had, you would have it inside the policy. You wouldn't have it in the company. So that's one way to get around the issue as well.
Makes sense. Makes sense. So, just being practical, right? Why business owners might wish to leave the existing business owned coverage in place is that they never get to a valuation that could pierce the estate or inheritance. Or the company's a corp and doesn't want to form a partnership, or one or more of the insurers no longer qualify for insurance. I would say that the subset of issues of leaving as is versus looking to revise are far fewer, right, than the special circumstances.
Yes.
I would think that every business owner, again, that meets one or both, particularly both criteria of corporate owned life insurance to effectuate a buy sell, or potentially subject to federal estate, state estate, or inheritance taxes, they are the folks that are most impacted. So I would say that, right, reminder, life insurance is still the best option, right? There's really only 4 other alternatives. It's cash, which, it's kind of like cash is king. I don't know why you would want to, utilize cash and you're off your balance sheet to exercise a buy sell. You can go to the bank and borrow money, not timely, not cost, inexpensive at this point in time. You could create a sinking fund through savings, but timing is very unpredictable, and an installment sale contingent on the future success of the business. But insurance gives you funds available from inception. The downside is the owners need to be healthy, and if you look at providing 15 years a buyout on a $1 million purchase price, life insurance is still by far the most cost effective way of doing so. We get into a little bit of like transfer for value, but it's probably beyond the scope of today's discussion as we kind of approach the close to this meeting and this webinar. Real world observations, based on like over 2,500 buy sell agreements is just some of the findings that we've uncovered. Is like some things that seem to be common sense are not included in existing buy sell agreements, Lena, and as simple as it's not signed, or there's no spousal consent language, or the agreement, 21% of the buy sell reviews have not been reviewed in more than 10 years, right? We talked about the valuation discrepancy and the uptick in valuations in multiples since 2019. It's quite alarming, right? There's different language, and that, right, the book language may not match the definition of disability, right? Disability is often overlooked. You don't speak to how you deal with the insurance. The pricing terms have no relationship to the value of the business, right? The life insurance ownership structure is completely different than the agreement reads. So, right, it is a wonderful service to be able to offer your customer the opportunity to conduct a no obligation, no cost buy sell review. And with 3 years tax returns and 3 years financial statements, we could also provide a complimentary informal business valuation. And these tools will get the conversation started. And you have not yet ever asked anyone to buy anything or go through a medical or anything of the sort. This is a true value add to kind of underscore the professionalism of what you do and the resources you have behind you at Life Brokerage and at carrier partners like Mass Mutual and Lena Storm. So, you know, I would say that you want to take advantage of the buy sell review, the informal business valuation, and business continuation proposal at every chance you can get.
Yeah,
Lena,
and I'm going to reiterate that this is one of the most fertile times to build business around these questions with the smallest companies that do extremely well, and they're really tightly controlled by the family or by a few owners. These are things they want to talk about. So you have if you can be an evaluation, if you could provide them a preliminary valuation of their business, they will look at you as providing tremendous value.
Lena, as we promised to wrap a little bit early. It's approaching 1 o'clock. I want to thank you for being with me today. Again, like such a tremendous resource. I can't thank you enough for the resources that you've built and the support that you lend Life Brokerage. You are a true pro. I remember many, many, many years ago, you taught me about conservation easements and you had me at hello, and we've just kind of followed your career, ever since, and you continue to thrive and evolve and build out tools that agents can like take to the field and actually execute on.
Good to be here. Thank you.
Thank you. Any closing thoughts or comments?
No, other than the fact it's a very fertile time to be talking to people about this and not to be afraid to bring it up at all. I would just simply say, did you hear about the Connelly case? We need to talk about your particular situation and make sure you don't have the same situation happen to you.
Yeah, I would say, Lena, there's a few leading does the business own life insurance? Is it are you filing your 101Js? Did you grab your notice of consent? Are you filing your 8925? Are you using that corporate owned life insurance to exercise a stock redemption buy sell? Are you potentially, including the business valuation and your life insurance proceeds, potentially subject to federal state estate tax, and or inheritance tax now or in January 2026? These are probing questions that will lead you to opportunities that can showcase your services listed on this screen, and again, separate you from the rest of the pack. So I want to thank everyone for joining us today. It's we're gonna wrap right on time. A copy of the slides will be distributed along with the recording and any handouts that we've promised along the way. So again, thank you for being with us. Lena, thank you again.
Thank you. Thank you all.
Appreciate everyone being with us. Be well.